This is Professor Kshitij Bansal. I teach at Jindal Global Law School of OP Jindal Global University. What we are going to discuss today is the convergence thesis within the larger topic of challenges and critiques of international humanitarian law. What would you learn after listening to my today's briefing? The students would learn about the interplay of the principles of human rights law paralleled to the principles of international humanitarian law and how one facilitates the effective implementation of the other. The modules also delve upon the identification of any identical or similar standards between the two varied categories of law and the implications of merging them into one. Let me brief you on the introduction about what this module essentially would carry within itself. This module is designed to familiarize you all with how HRL informs IHL obligations in the times of conflict. This module in particular seeks to critically acquaint you all with the manner in which these principles would intersect with IHL, drawing attention to the possible overlapping of goals of the two instruments. This module also seeks to shed light on the principle of derogation and how it sheds light on the relevance of HRL in times of armed conflict. One method that this module highlights is the minimum humanitarian standards approach. This method aims at identifying a minimum set of common standards drawn from both the regimes. This method identifies the minimum standards that overlap between IHL and HRL. The Human Rights Committee's General Comment 29 rooted the common element in the theoretical abstraction of human dignity. Therefore, as per this thesis, there is a common theoretical goal for both the instruments. The convergence thesis gets credence from the fact that there are certain rights that are deemed as non-derogable, which is to say that the right cruel and degrading treatment, for instance, must be respected in times of conflict as much as in times of peace. What is convergence thesis? This module examines the convergence between human rights law and international humanitarian law. The non-specialist can be excused for confusing humanitarian law with a similar sounding human rights law, or not realizing that it is actually a euphemism for the law of war or the law of armed conflict. However, like a viscous liquid taking the shape of its container, humanitarian law is beginning to be reshaped by the humanitarian connotations of its name. In particular, Common Article 3 of the Geneva Conventions provide protections against violence, degrading treatment, and extrajudicial executions, repeating in a more general form some of the same non-derogable rights in the ICCPR, which is International Covenant on Civil and Political Rights of 1966. Before discussing the implications of the merging of these two bodies of law, we can identify numerous parallels between the International Covenant on Civil and Political Rights, that is human rights law, and the Geneva Conventions, that is international humanitarian law. First would be prohibitions against torture and degrading treatment, which can be found in Article 7 of the ICCPR and Article 13 of the 3rd Geneva Convention, Article 32 of the 4th Geneva Convention, and also Article 11, Clause 2 of the 1st Protocol and Common Article 3. Next would be the arbitrary arrest and detention provisions, which are covered in Article 9 of the ICCPR and is also addressed in Article 21 of the 3rd Geneva Convention, governing internment as modified by Part 3, Section 6, Chapter 3, prohibiting close confinement, then also in Articles 42 and 78 of the 4th Geneva Convention, which are about due process rights in situations of internment, as well as Article 75 of the Protocol 1 and Articles 5 and 6 of Protocol 2. Third similarity and overlapping would be non-discrimination, which can be found out in Articles 2 and 4 of the ICCPR, as well as Common Article 3 to Geneva Conventions, Article 7 of Protocol 1, Article 2 of Protocol 3, Article 6 of the 1st Geneva Convention of 1864, which protects combatants, whatever nation they may belong to, Article 4 of the 1929, which accords impartial treatment regardless of rank, mental health, or sex. Article 12 of Conventions 1 and 2 of 1949, Article 16 of the Third Convention, and Article 27 of the Fourth Convention. Then would come the similarities in terms of due process rights, minimum standards protecting life and liberty and property, which can be found throughout the ICCPR, including Article 2, which is remedies, Article 9, which is arrest remedies, Article 14, which is about fair trial, as well as various parts of Geneva Convention. The comprehensive version of the latter is Section 4, Chapter 3 of the Third Geneva Convention, which provides various penal sanctions and due process rights of prisoners of war. Then Articles 103 to 106 of that convention provide for a minimal juridical process, including a right to counsel and the right of appeal. We won't stop here. There's right against self-incrimination in ICCPR, Article 14, Clause 3, Subclause G, which has parallels in the Third Geneva Convention, Article 99, Clause 2, First Protocol, 75, Clause 4, Subclause F, and Protocol 6, Clause 2, F. The Fourth Convention, Articles 65 and 67, First Protocol 75, Clause 4, and the Second Protocol 6, Clause 2, Subclause C. Various due process rights are also catalogued in Article 75, Clause 3 and 4 of the First Protocol, Article 6 of the Third Convention, and also by common Article 3. At its simplest, the convergence thesis is the idea that these two sets of law protect the very same rights and call for their enforcement under different circumstances. This is a popular emerging view among international lawyers. One writer, Professor Ruti Tetil, has even erased the IHL-HRL distinction and merged them both under the heading humanity law. It should be noted that the next module will provide a contrary view based on the traditional international law principle of lex specialis and lex generalis, which holds that the two bodies of law remain separate, with HRL applicable at times of peace and IHL applicable in the times of armed conflict. What is the support for the convergence thesis by the Human Rights Committee? The Human Rights Committee declared in General Commitment number 29 that during armed conflict, whether international or non-international, rules of international humanitarian law become applicable and help in addition to the derogation provisions to the provisions in the first paragraphs of Article 4 and 5 of the Covenant, respectively to prevent the abuse of a state's emergency powers. Article 5, Clause 1 of the ICCPR stipulates that the restrictions imposed must not be aimed at the destruction of any of the rights recognized in the international order. An international committee of the Red Cross summary of the conclusions reached at the gathering of humanitarian law experts states the following: the great majority of participants simply recalled that IHL represented a special law inasmuch as it has been specifically framed to apply in a period of armed conflict. They noted that in offering ground rules adapted to this particular context of violence, this body of law makes it possible in many cases to specify the precise content of the non-derogable human rights. These statements demonstrate the cross-pollination of ideas between those applying international law from the point of view of HRL, IHL, and the general international law. Another horizon where all three might meet may lie in the ICJ's long-brewing general clauses on humanity, which not only indicates non-derogable protections in IHL, but also that certain obligations may arise. Also from the principles and rules concerning the basic human rights of the human person, some of which have entered into the body of general law. The enforceability of non-derogable human rights, even in situations of armed conflict, would be consistent with long-term trends towards the humanization of humanitarian law, which differ in details but accept in principle that there are certain core rights to human dignity that provide the mandatory minimum protection available in IHL. What are these minimum humanitarian standards we're talking about then? One may stop one step short of arguing for the complete convergence of the two regimes by adopting a more cautious method. An alternative way of reconciling HRL with IHL is to identify a minimum set of common standards drawn from both regimes. Scholars have argued for a vital core of minimum principles applicable in grey areas, particularly internal strife, involving the uncertain borders between international and internal armed conflict, between armed conflict and civil disturbances, as well as between military force and law enforcement. In 1966, Jean Piquet identified a certain parallelism between HRL and IHL. While Piquet rejected convergence of two systems, he proposed three broad principles common to HRL and IHL. First being the principle of inviolability, second the principle of non-discrimination, and the principle of security. This vital core has been reflected in subsequent declarations of minimum principles. Since the 1980s, Professor Theodore Miron has argued for the creation of a new international instrument covering such grey areas between the reach of humanitarian law and human rights law. Several studies on minimum standards have been premised on the fact that each system offers, in some areas, greater protection than the other does. The general comment also emphasized that international humanitarian law remains in force even where states take steps to derogate from certain provisions of the ICCPR, Article 4, Paragraph 1, requires that no measure derogating from the provisions of the covenant may be consistent with the state party obligations under international law, particularly the rules of international humanitarian law. States parties may in no circumstance invoke Article 4 of the Covenant as justification for acting in violation of humanitarian law or preemptory norms of international law. The enumerated minimum standards articulated in the general comment include the following. All persons deprived of liberty must be treated with respect for their dignity. Hostage taking, abduction, and unacknowledged detention are prohibited. Persons belonging to minorities are to be protected. Unlawful deportations or transfers of population are prohibited. And no declaration of the state of emergency may be invoked as justification for a state party to engage itself in propaganda for war or in advocacy of national, racial, or religious hatred that would constitute incitement to discrimination, hostility, or violence. While this is an advance for the articulation of these principles, we should also consider the drawbacks of this approach. As we shall see later in more detail, one of the reasons humanitarian law is more palatable to emergency governments than human rights law is that it seems deceptively simple to apply. It lists a few things a state cannot do under the rubric of military necessity, and it seems to give blanket permission otherwise. Similarly, the enumeration of non-derogable rights, if separated from other derogation procedures, may result in an intolerable default position that states may take during all kinds of emergencies without regard to unproportional. It is true that the uneasy overlap of functions between these human rights bodies and institutions applying humanitarian law are potentially more troublesome. Formally, the density of contacts between these systems will probably increase because of the definitional malleability of violent crisis and because they have been put into a possible relation by the ICJ's nuclear weapons case. In a more realist mode, the US demonstrated this in its Guantanamo detentions by ignoring human rights standards and only gesturing towards humanitarian law. The greatest danger to a system is that it will become isolated and irrelevant, for else tokenized. It also remains possible that the emergence of a coherent international counter-terrorism regime could displace this patchwork of human rights norms altogether. The ICJ continued to discuss this in the advisory opinion of 9 July 2004 on the legal consequences of the construction of a wall in the occupied Palestinian territory. Further, paragraph 216 of the later Uganda advisory opinion finding in the court continues with pragmatism and pluralism. The protection offered by human rights conventions does not cease in case of armed conflict, the note held. As regards the relationship between international humanitarian law and human rights law, there are thus three possible situations. Some rights may be exclusively matters of international humanitarian law, others may be exclusively matters of human rights law, yet others may be matters of both these branches of international law. Let's now talk about derogation clauses in human rights instruments, a tool for convergence or not. The derogation clause of the human rights treaties and similar minimum standards in humanitarian law. Finally, there is the minor puzzle of the consistency clause that occurs in each of the derogation provisions and what this might mean for the coordination of norms. For example, ICCPR Article 4 Clause 1 provides that in the event of a public emergency which threatens the life of the nation, a state may derogate rights to the extent strictly required and in accordance with other international obligations. As we shall see, this could be read as referring to obligations under the Geneva Convention, which implies that the coordination of the norms of the derogation clauses with other regimes in international law must take place. A contrast is often drawn between the derogability of rights in the human rights treaties and the non-derogability of humanitarian law standards. In practice, this contrast is misleading. In some respects, humanitarian law may be more effective than the human rights conventions in protecting some important human rights during emergencies, but it cannot be presumed to represent a higher standard of protection. First, human rights are in theory protected in all times, peace, war, and national emergency. Secondly, unlike human rights law, humanitarian law traditionally balances its protections of human dignity against military necessity. In substance, humanitarian law is actually an alternative system of derogation. When translated into rights discourse, it lowers protections in a manner as if all derogable rights were suspended under the human rights treaties with some exceptions. In any case, it is not possible to decide one is more protective than the other in the abstract without knowing the nature of the complexity of the emergency or the case at hand. We can see three approaches to trying to reconcile these two subsystems. First, analytically, we can see that both human rights conventions and humanitarian law have a compatible role as emergency baselines or minimum standards. Attempts to formulate a lowest common denominator approach to humanitarian law human rights protection have been formulated in documents such as the Turku Declaration, which is aimed at identifying the protections available in the situations of emergency or violent conflict that overlap in human rights and humanitarian law. Secondly, all of the derogation provisions are accompanied by consistency clauses, stipulating that the derogating states may not adopt measures that would be inconsistent with their other obligations under international law. Although there is scant evidence and no state practice to support this claim. Thomas Burgenthal has argued that this stipulation could only mean that the obligations of the Geneva Conventions are among the non-derogable rights reinforced by human rights treaties in circumstances of violent conflict. Presumably, this would only apply to states that have already agreed to the relevant provisions of Geneva Conventions. In the three treaties, consensus exists for non-derogability of four fundamental rights, which are right to life, the prohibition of torture, the prohibition of slavery, and the prohibition of retroactive criminal laws. Reasoning that abuse of these four rights are enabled by other derogations, however, the Paris minimum standards also proposes that the addition of non-derogable status to freedom from discrimination, the right to liberty, the right to a fair trial, and the right to remedy. Like the privileging of specific over general, this publication of emergency baselines is yet another strategy for the coordination of norms to escape fragmentation. In 2001, the Human Rights Committee, the body established to monitor the implementation of the ICCPR, published General Comment number 29, which was a victory for the drafters of the Paris Minimum Standards. Measures derogating from the provisions of the covenant must be of an exceptional and temporary nature. Two fundamental conditions must be met, which is the situation must amount to a public emergency that threatens the life of the nation, and the state party must have officially proclaimed a state of emergency, noting that the latter requirement is essential for the maintenance of the principles of legality and rule of law at times when they are most needed. Can we conclude by saying that the constant practice of mainstreaming human rights into every institution possible has been a part of international law since World War II? The Convergence thesis makes a case for us to wonder whether we have mainstreamed rights into the institutions and laws that govern war. We must wonder how an activity as violent as wars be capable of preserving rights in sync with the activity. The Convergence thesis seeks to answer that question. Some have argued that it comes from finding a minimum core of IHL and HRL that necessarily brings with it an overlapping consensus. With this in mind, this briefing has explored the idea of what constitutes a convergence between IHL and HRL. This section has argued and urged the reader to explore the possibility of derogation constituting a tool for convergence. As noted in the previous section, there are 4 non-derogable rights that must be in force even during times of war. They are right to life, prohibition of torture, prohibition of slavery, and prohibition of retroactive criminal laws. This list is now in the process of being expanded with Paris Minimum Standards asking for other rights to be incorporated, with more rights being incorporated into this expansionary definition of minimum standards and non-derogable rights. This section urges the listener and the reader to think of the possibility of a convergence of HRL and IHL where certain rights deemed inalienable operate during the times of war. I hope this was interesting and informative. Thank you for listening.